Yes, it would. And it would also show up with the Department of Justice. Just getting arrested for a DUI, the arrest could show up even before there's any potential conviction. And once there is a conviction, then what would happen is that when your record is run, a wet reckless would show up because it is a misdemeanor. And misdemeanors and felonies show up on criminal records. Now, what could happen, the nice thing about a wet reckless compared to a regular DUI is the length of probation. A DUI is 3 years, a wet reckless is typically 1 year. It should be 1 year. And that means you're off probation quicker. That means you can get an expungement quicker, and your criminal record would show that the charge has been dismissed or the conviction has been dismissed. Once it's been granted by the court, you need to get a lawyer. You should get a lawyer to do it to make sure it's done right. And then what happens after the court has granted it is the clerk's office in the Marin County Court will send the expungement, which is basically saying that the court has dismissed the case. They send it to the Department of Justice, and that department updates the records. It usually takes a month or more for it to get updated after it's been granted. But unfortunately, going back to the initial question, a wet reckless is a misdemeanor. It is a criminal conviction, and it would show up on your record as that conviction.